I believe we're starting. Sorry. Welcome to the latest webinar from the ABA section of Civil Rights and Social Justice, brought to you today by the ABA's HIV/AIDS Coordinating Committee. My name is Richard Wilson. I'm a lawyer in private practice in Chicago, and I serve as chair of the committee. If you like our work, we invite you to become a member of the CRSJ section and collaborate with us on projects you may want to develop and offer to our members and the general public. During today's program, you can ask questions of our panelists by finding the questions drop-down box on the right-hand side panel and typing in your questions. There will be a time at the end for panelists to address them. Also on the panel is the handouts drop-down where you can access our written materials and PowerPoint presentations. We will be sharing a recording of this program with the handouts to everyone who is registered so that you can share widely with your networks. Please feel free to leave us feedback or ask us questions to follow up. We're thrilled to bring you today's program, which is entitled AIDS 2019, a roundtable discussion on current and emerging legal policy issues. In the 33 years since the first AIDS cases were identified in the United States, the HIV epidemic has evolved from a global pandemic to a manageable chronic condition in the West. The legal and policy issues and responses have evolved as well, and not always wisely. The ABA's AIDS Coordinating Committee was established in 1987 to identify, analyze, and address these issues, and in our program today, we will discuss the progress made and the challenges remaining to achieving a quote-unquote AIDS-free generation. With that said, I'd like to introduce our moderator, Allison Nichol, a longtime member of the committee. Allison is formerly with DOJ and is presently the director of legal advocacy, for the Epilepsy Foundation. Allison will introduce our panel, nearly all of whom also serve as members of the committee. Thank you. There's Margaret.
Hi, Margaret.
Seems to me we're having technical difficulties getting Allison on. Can you still hear? Sorry?
Anthony, if you want to go into your program, we're going to...
Yeah, I didn't want to just start, but just since we're waiting for Allison. Hello, everyone. My name is Anthony Pinggera. I am a law fellow with Lambda Legal in the Los Angeles office, and I'm going to be talking today about some of the cases that Lambda Legal has filed on behalf of people living with HIV against the U.S. military. So, just as a brief 30,000-foot overview of the military's policies related to people living with HIV, there is an overarching Department of Defense policy that people living with HIV cannot enlist or become commissioned officers. They also cannot enlist in service academies or enlist in the National Guard or reserves. This rule has also been interpreted to mean that once you are in the military, even if you are active duty, if you want to move from enlisted to officer status, you cannot do so. And there's a separate rule saying that people living with HIV, with some very limited exceptions in the Navy, can't deploy overseas at all, which has really negative implications for a person's career. However, there's also a rule that says if you are living with HIV and you're an active duty member of the military, you cannot be removed from military duty solely on the basis of your HIV. There has to be some other extenuating circumstance in addition to your HIV status that makes it unable for you to continue your military service. But in the last year, that has changed a little bit because the Department of Defense put out a new rule last year, which we have been calling the deployer get out rule, which says that if you are undeployable, which means you can't be sent overseas in any way for more than 12 consecutive months, that you should be discharged from the military. And as I just said, HIV is one of those conditions that, as a rule, you are not able to be deployed overseas. So most of these people living with HIV are facing discharge at this point. So we have 3 related cases. They are in 2 district courts. 2 are in the Eastern District of Virginia. 1 is in the District of Maryland. And we have 5 plaintiffs between 3 cases. We have, the cases are called Harrison versus Shanahan, Deese and Doe versus Shanahan, and Rowe and Vo versus Shanahan, all of which till recently were versus Mattis. So quick background on all of these cases, because the cases are all very closely related, but they have their own unique tack. So Harrison is, I would say, our marquee case. It was the first one we filed. So Nick Harrison is our plaintiff. He is an 18-year Army vet. He joined in 2000, and he served active duty in an airborne unit until 2003, at which point he moved over to the National Guard. And he has served 2 tours of duty, 1 in Afghanistan and then 1 in Kuwait. His most recent tour of duty ended in 2012. During the time he has been an active duty and reservist, he has gone to college on the GI Bill, he has gone to law school on the GI Bill, and he wants to become a Judge Advocate General officer in the DC National Guard. He seroconverted in 2012, right after coming back from his 2nd tour of duty in Kuwait. He has been undetectable pretty much ever since his diagnosis, in part because the military actually has very strict rules about the treatment that you must receive as a person living with HIV if you seroconvert while you are already in the military. Basically, the rule is that you have to be in treatment if you are a member of the military. He is in excellent physical health. He has scored the highest possible physical scores on all of his tests every time. And he has been approved for this particular position in the DC National Guard, with the exception that he is considered undeployable because of his HIV status. And so he is ineligible. And he has been trying to get this job since 2014. And so he is our first plaintiff. Our second 2 plaintiffs are Deese and Doe. They are 2 service academy cadets at different service academies. Our plaintiff Deese is from the Naval Academy. Doe is from the Air Force Academy. They both seroconverted while in school. And the service academies all have the same rule about people who seroconvert while you're actually in school, which is if you seroconvert before your senior year, you're supposed to be allowed to finish your year, and then you have to leave. But if you seroconvert during your senior year, you can graduate and you're given a degree, you just aren't given a commission. And that's what happened to both of our plaintiffs. In a weird twist, Doe actually seroconverted during his sophomore year, but the bureaucratic process took so long that by the time they decided that they might separate him, it was his senior year, and then they decided just to let him finish. And then our third case is Rowe and Vo. And so these are actually both active duty enlisted service members. They're both members of the Air Force, and they are actually being separated, as opposed to Harrison, who is actually still a member of the National Guard. He's just been kept as a sergeant, even though at his current level, if he was given this JAG officer job, he'd probably be a captain or even a major by now. They are actually being separated. They have been told that their HIV status makes them a burden on their particular units, and that they can no longer serve as members of the military, even though both of them are actually, they're serving domestically. They're not deployed overseas. They have been deployed overseas in the past. One of our plaintiffs to South Korea, but they're currently serving not overseas. So all of 3 of these cases has slightly different claims, but the thing that they all have in common is we have an equal protection challenge to the DoD policies on the basis of HIV. There is also claims in 2 of our 3 cases under the Administrative Procedures Act, which I'm not going to get into the weeds on the APA because it is a really easy statute to get lost in. But basically, what we're arguing in both Deese and Doe and Rowe and Vo is that the military has certain procedures by which people are supposed to be separated or considered for separation involving different medical checks and evaluation boards. And we're arguing that the military didn't follow their own procedures, or if they did, they came to an arbitrary and capricious decision that's not in line with their own policies. But that's not the main claim in all of these cases. The equal protection claim is really where we're making our big push, and it's where I would argue our novel theory is. So I think everyone here knows that HIV is often treated in the law as a disability, particularly when you're talking about things like the ADA. Most of the time, this is really helpful, but in the specific context of equal protection, it can make things more difficult because, as the Supreme Court said in Cleburne and then read in Alabama versus Garrett, disabilities, and in Cleburne, specifically mental disabilities, they only get some form of rational basis review and not heightened scrutiny. Now, we run into this really interesting tightrope that we have to walk, where we're not arguing that HIV should no longer be considered a disability. But what we say is that disability is a term of art that means different things in different statutes. So, for example, the term disability under the ADA is very broad, whereas under certain Social Security provisions, what constitutes a disability is very specific and is actually a lot more difficult to achieve. So our argument is not that Cleburne's wrongly decided. It's that HIV is actually unique among different disabilities and should be considered separately and given its own form of heightened scrutiny. And the way we do that is we apply the factors that were first laid out in Frontiero and then applied in Cleburne, and arguing that this actually indicates a different level of scrutiny that should be applied. And so the four factors are a history of stigma or discrimination, a relative lack of political power, the immutability of the characteristic, and the ability of people with that characteristic to contribute to society. So I don't think I need to tell anyone here on this call about the history of stigma and discrimination against people living with HIV. We go into that in great detail in a lot of our motions. We also argue about the relative lack of political power, which, though it has been increasing recently, we do point out that there are no federal legislators openly living with HIV. There's a bare handful of state legislators openly living with HIV. And obviously, immutability of the characteristic as an incurable chronic condition, that's easy. And then we spend some time talking about the ability of people living with HIV to contribute to society at the same level. And that's where we are able to build on a lot of the work that ourselves and everyone else on this call today has been doing, basically saying that HIV doesn't limit your ability to serve in any meaningful way. There is no job in the world that a person living with HIV can't do just as well as anyone else, barring some other unrelated medical complication that has nothing to do with their HIV status. And we even point out that people living with HIV can safely conceive with certain prophylactic practicing. It is a side note in these particular cases, but it's emphasizing our points. In the alternative, we argue that even under some form of rational basis review, we still succeed because the stated justifications that the Army presents are so untethered from science, because they were written in the late 80s, as to be irrational to the current realities of the landscape. So, for example, they argue that there is a risk of what are called battlefield transmissions, basically transmissions via blood splatter. And we have expert testimony saying that, or expert reports saying that there is actually no demonstrated risk of battlefield transmissions from blood splatter. There is this thing in the military called the walking blood bank, which is kind of what it sounds like. It's the ability of active duty service members to actually give blood directly from themselves to another service member in a dire situation. There is a concern that the Army has raised that people living with HIV would be part of this walking blood bank. And we easily point out that the walking blood bank is a voluntary program. And so no person living with HIV is going to volunteer to be a donor in the walking blood bank. They also argue that it is difficult to get and administer HIV medication across the world, to which we point out that there are a number of other conditions that people are allowed to deploy to frontline combat duty in which they are required to take once daily medication. High blood pressure is one of them. Malaria medications is another. A lot of these are self-administered. They're carried around in 90-day supplies. Also, recently, the military has issued new rules saying that people can be prescribed PrEP and then, on a case-by-case basis, perhaps be deployed. And as a lot of people know, PrEP and single tablet regimens are often very similar, if not identical. So it's a little bit of a irrational rule. So where we are in all three of these cases, because we did file them at slightly different times, and so they're in slightly different spots. So in Harrison, we filed a motion for preliminary injunction a few months ago, and the government filed both an opposition to our motion for preliminary injunction and a motion to dismiss. They claim the military should be given deference to make their own personnel decisions, and alternatively, that the policies pass muster under rational basis review, and arguing that rational basis review is the law that must be applied in the circuit because they have a couple of cases that say, well, the Supreme Court said in Cleburne that disability gets rational basis review, HIV is a disability, see Bragdon, ergo disability, HIV gets rational basis review. No real meaningful analysis was done, and that is a case from 1995. So our motion for preliminary injunction was denied, but so was their motion to dismiss. So right now we are in discovery in Harrison. The judge, Judge Brinkema in the Eastern District of Virginia, definitely wants a full record developed in the cases, and we have been trying to comply with that request. It is the Eastern District of Virginia. Things are moving very fast. Our fact discovery deadline closes in 6 or 7 weeks. And the government has been, to put it mildly, slow to respond. In Deese and Doe, those cases have actually been stayed. That's the case in the District of Maryland, because the requests for both plaintiffs are currently in the sort of administrative court of last resort. It's called the Board of Corrections and Military Records for each of their individual service branches. There is not really a consideration. There is a hope that perhaps the decisions that have kept them from commissioning will be overturned. It's unlikely, but it is possible. So the cases have been stayed pending the decisions of those boards. And then in Roe and Vo, which is our most recent case that is also in the Eastern District of Virginia, is before the same judge as Harrison. We filed a motion for preliminary injunction. In that case, slightly different ask, because these are two people who are actually being discharged on account of their HIV status. So we're arguing the harm is a little bit more urgent. Some of them are being discharged as of the end of this month. And the government opposed. We filed our response last Friday. So we should have a decision on that very soon, because as we all know, the Eastern District of Virginia moves very quickly. And I believe that was all that I had. That is the state of our current military cases. It's a really interesting case. The three of them together make for a large and fascinating and fast-moving novel case for us. So happy to answer questions on that later, but that's about all for me.
Okay. Thank you, Anthony. I'm not on the video anymore. Margaret, you're next. Would you like to introduce yourself, because we're having trouble getting the moderator on? I mean, I can read the bios, but they're fairly limited, and you can also self-introduce, as it were. Margaret Drew, by the way, is co-chair of the committee, and I'll just say she's also an associate professor of law at UMass School of Law. Margaret, you're next, so if you wouldn't mind, and I apologize to everyone. I'm not on video at the moment, but we're having a bit of technical difficulty, so just to keep it moving, I'll just throw it on to, toss it off to Margaret. Thank you, Mark. Your audio's off, Margaret. There you go. I think. No. There should be a little microphone icon.
Margaret, Ronda, would you like to go?
Rhonda, your audio's off as well.
How about I'll go forward and we'll give Margaret an opportunity to find
Perfect.
her audio, okay?
Thank you, Rhonda.
So I'm Ronda Goldfein. I'm the executive director of the AIDS Law Project of Pennsylvania, which is a public interest law firm that's been providing free legal services to people living with HIV for 30 years. I'm also the vice president of a new organization in Philadelphia called Safe House, which is a public health approach to provide overdose prevention services. I was asked to talk about something that's biomedical in nature, but not necessarily biomedical with regard to HIV, but biomedical in nature, and that's America's overdose and opioid crisis. You know, we talk a lot about the opioid crisis, but what we're seeing in Philadelphia and across the country is also an overdose crisis. In 2017, more than 70,000 people died of what could have been a preventable opioid overdose. Those numbers have increased steadily since 2010, and then in 2013 increased at an even greater rate because of the introduction of synthetic opioids, primarily fentanyl. In Philadelphia, folks will say that the heroin on the street is all fentanyl. It may have some heroin in it, but it's really a fentanyl crisis here. I think that's probably the same in most of the northeast and middle of the state. I hear things may be a bit different in California, but I'm not sure. So the AIDS Law Project sees this overdose crisis in our city, and we think that as an organization that has had 30 years of responding to a public health crisis, that this is something that we can be involved and to help. And so I want to share some of the ideas that we've had about how lawyers, public interest lawyers, private lawyers, how lawyers can help address the opioid crisis. So the first thing is you need to look at the issues locally. Every state obviously has its own players, and you need to get a sense of what's happening where you practice. You know, is it possible for you to add something to your legal practice to address the epidemic? So you have to know who's out there and what's out there. Once you get a sense of the players, you need to learn about harm reduction. And for some folks, this is, you know, things that we've been talking about in HIV for 30 years. But harm reduction is a recognized, effective public health strategy. Many of the risks and dangers that harm reduction seeks to address are things that in fact have been created by or exacerbated by the legal justice system. Harm reduction is, is a set of practical strategies that focuses on minimizing the harm rather than attempting to eliminate the behavior, right? It's a realistic approach to what people's lives are really like. We all know the just say no era didn't work, right? We all know that saying use condoms every time, all the time, that doesn't work, right? It's about minimizing risk when possible. And as I said, it became emerged globally in the 80s as a response to HIV, particularly for people who were using injection drugs. But if you think about harm reduction, you can see it in a lot of different approaches. Right? Comprehensive sex ed for harm reduction. Free taxi policy. Free taxi programs during the holiday season. Also harm reduction. Condom distribution in prisons. Non-tobacco delivery. Nicotine.
Unavailable, so please leave us a message and we'll call you back.
I'm not sure what that is. And the decriminalization of sex work. Again, all examples of harm reduction. So the important harm reduction that you literally and figuratively meet people where they are, right? We're not asking folks to come to our accepted idea of how you get legal services and what you need to do. To be of real value, we have to understand where the clients we hope to serve, where they are. Another principle of harm reduction is that we have a range of experience for people with lived experiences. And that's the expertise that we need to tap into. It's not a bunch of lawyers deciding what's best for a particular population. It's asking that population what works best for you. A third principle of harm reduction is around the social determinants of health, right? We are where we live, where we work. That influences the risk that we face, and it influences our outcomes. And so we always need to keep that in mind. When we think about the whole notion of harm reduction, we have to recognize that we're trying to reach out to the clients who need assistance, but we're going to do it in a way that's respectful of what they need. So you decide you want to play your role in addressing the opioid crisis. You figure out, yeah, I need to understand more about harm reduction. There's tons of material written on it. It's a really fascinating public health intervention. So then what? Well, find the harm reductionist in your neighborhood, right, in your area. Because if you're going to want to provide legal services to a vulnerable population, you have to work with the harm reductionist and that they accept you into their network. We're not going to design it and then foist it upon people, or at least we're not going to do that in a way that's going to be effective. That requires us all to, and I like to think that folks working in HIV, we have already gotten the non-judgmental part of our practice down, but that it's a continuation of that practice. We have to figure out where the clients are physically located. To understand that in Philadelphia, for instance, there is a psychic border at Girard Avenue. Some clients are just not coming south into Center City. And if we want to provide service, then we need to go to where they are. When we talk about embedding or partnering with harm reduction organizations, and we think about this notion of maybe embedding legal services there, not unlike what many folks are doing on an MLP practice, a medical legal partnership, right? We want to make one-stop shopping. We want to be able to combine the disciplines so that we are giving the client the services they need, whether it's medical services, legal services, counseling services, get everything in one bit. We also, once we figure that all out, or actually, as we're figuring it all out, always make sure to ask how we can be helpful. And that sounds kind of basic, but we have all seen the well-intentioned bigfooting over strong social service groups saying, well, this is what you need. And we need to, like, as lawyers, take a step back and, you know what, we may not know it all. We need to talk to our social service colleagues and ask them what they need. So we get to that point, and then we think about, well, what's possible, right? What are the things that we can, right? So at the AIDS Law Project, we have a long-standing relationship with our friends at Prevention Point Philadelphia. That's an organization that started 26 years ago as a syringe exchange program, but has grown to much more than that. And they have a HIV clinic, they have hepatitis clinic, they have access to treatment. They're really a full-service public health clinic starting from syringe exchange. So we have been embedded at Prevention Point providing legal services. And some of the things that we have been offering their clients is like a quick connection to the AIDS Law Project. And so we started off providing for their clients who were people living with HIV, the full range of legal services the AIDS Law Project offered. And then we were trying to do, a kind of a different service for people who were at risk. And we felt like that was cumbersome. There were some privacy concerns. So now we offer a full range of legal services for people who are living with HIV or at risk that get their care from the syringe exchange / public health program that's in the heart of Kensington. Excuse me, that's in the heart of Kensington. One of the specifics that we're providing is helping folks with birth certificates. We've seen so many people get jammed up. You can't get into rehab because you don't have ID. You can't get ID because you don't have a birth certificate. When folks are recognizing that they need treatment, that's not the time where we say, great, okay, give us 2 weeks to figure out some bureaucratic mess and we'll get back to you. So we're trying to get people empowered with their birth certificates and their IDs. So when they're ready, they have their documents. And we have also worked on creating low barrier programs so that you say you're ready today, you can go today. We will be working while you're getting care on getting all of your documents. We also have a warrant resolution program. As some of you may know, that the having an outstanding criminal warrant was an impediment to get certain public benefits based on where you live. And so we started to help folks resolve their warrants. And really the idea is about building trust in communities where maybe they're not so happy to see lawyers. Maybe lawyers have not been good points in their lives. But that we create we change that narrative and say, no, we are here to help, we can make a difference. Some of the ways in which the AIDS Law Project has helped at prevention point and things for folks to consider on working on in their, if they find a harm reduction community in their area, is that we have provided assistance with sex worker-led challenges to prosecutorial practices. This is people who are being arrested for having condoms because that was used as evidence of an intent to commit a crime. So we provide some assistance in there. It's kind of a unique practice. The other thing to consider is let's be bold, right? We heard a lot about bold steps recently. So let's be bold. Let's think about pioneering new initiatives. Let's think about how do we help our harm reduction friends get naloxone to the street. Naloxone is saving lives. It has the potential to prevent every opioid overdose from becoming fatal. But you have to have it. You have to get it out there. You have to have people trained to use it. You have to have protocols to use it. So we have been working with Prevention Point to assist them in their grand efforts to get naloxone out to the streets where people need it. We've also been working on Safe House, which is Philadelphia's public health approach to overdose prevention. And it's a multi-component program that begins with supervised consumption, supervised observation, and then access to treatment, whether it's access to MAT, medically assisted therapy on demand, whether it's other kinds of primary care that's needed, whether it's counseling, whether it's legal services, social services. It's the full range of wraparound services. And that we are optimistic that that's the kind of program that gives people an opportunity, right? If we can save somebody's life today, then maybe they're going to make better decisions about treatment tomorrow. I just want to conclude with, as some of you may know, if you're following the news out of Philadelphia, our Safe House initiative was sued yesterday by the U.S. Attorney for our district. We've had a open and, I would like to think, cordial disagreement with the U.S. Attorney's office. His position is that supervised consumption sites are in direct contradiction with a federal law. They call it the crack house law. The crack house law, the purpose is you may not legally maintain a place for people to use drugs. And we say, that's fine. We're not doing that. We're maintaining a place for the purpose of saving lives and getting people into treatment. Yesterday, the U.S. Attorney's Office filed a civil action for a declaratory judgment. It's a one-count complaint. Says that they think it's illegal. We think it's not illegal. We're grateful that the U.S. Attorney hasn't come in with a heavy hand and tried some of the more aggressive measures to stop our efforts. So we'll remain optimistic that in a judicial setting with a fair and impartial judge, that we will be able to explain our position. The U.S. Attorney will explain their position, and we hope we will prevail. So more to come on that. Thank you.
Great. Thank you, Rhonda. I don't know if anybody can hear me anymore, but
Yes, we can.
Margaret, I need you to send me an email or call me so we can get you on.
Can you hear me?
Because you don't see the chat box. I need you to work with the chat box. Dan, can you go next? Would you mind? And introduce yourself, Dan. Is that okay?
Sounds
Sure.
good, Richard.
I will go ahead and do that. Hi, everyone. Thanks for joining us this afternoon. My name is Dan Bruner. I'm the Senior Director of Policy at Whitman-Walker Health, which is an federally qualified health center in Washington, D.C. that since really the outset of the HIV epidemic has specialized in HIV treatment and prevention. We also have a mandate to provide care to the LGBT community. And I really wanted to talk about some of the legal and policy issues related to the biomedical innovations, which are so exciting in HIV treatment and prevention. And there are really two of them. One is that it's now the standard of care for everyone who's received an HIV diagnosis, whether their condition is at an early stage or at a more advanced stage. The standard of care is for them to be on antiretroviral therapy right away and to stay on that therapy. It's very clear medically that people who are on the long-term antiretroviral therapy experience a lot of benefits. They have a much greater chance of living a very long life and avoiding a lot of the complications related to advanced HIV infection that come with depletion of the immune system. So it's really important for somebody's own health to get on the therapy right away and stay on that therapy. It's also now clear that that has enormously exciting implications for prevention efforts as well, because it's clear that someone who is on therapy and whose viral load as a result is pretty much completely suppressed and remains suppressed for at least a couple of tests in a row over a period of a few months, is not able to transmit the virus to someone else sexually, whether or not condoms are used. And so that's an enormous advance. We've really known that for at least a couple of years, but the scientific community and public health establishment is finally endorsed it in a big way. The CDC, the National Institutes for Health have endorsed this, and it's given rise to a campaign that is styled the U equals U campaign. If you are undetectable, if your viral load is undetectable, then you're untransmissible, or you basically can't transmit the virus to others. So that's an enormous advance. There are a couple of challenges related to that. One is that not everyone who has HIV infection is on the therapy. Not everyone even is diagnosed or knows that they have HIV. Not everyone who knows they have HIV is engaged in care. And not everyone who's engaged in care is successfully virally suppressed. And the most disturbing thing about that is that it's very clear that there are striking and very disturbing racial disparities in that what's called the treatment cascade. So people who are people of color, especially if they're Black or Latinx, they're less likely to be virally suppressed. And besides that just being a real challenge for public health and justice, it also raises some interesting legal and policy challenges, one of which relates to criminalization. There are still too many states that have criminal laws on the books that make it either a felony or sometimes a misdemeanor to have any type of sex or certain types of sex with someone, at least without disclosing your HIV status, even though from a scientific or medical point of view, the risk is very, very slight of any transmission. So the medical establishment and the public health establishment is now making the really important point that the U equals U campaign or HIV treatment as HIV prevention kind of makes these criminal laws obsolete. Not that they were a good idea to begin with, but the evidence against them is even more overwhelming now. But then the question is, if you reform the laws, how do you go about doing that? And should you reform the laws by taking into account whether someone is virally suppressed? And if they are, should that then be a defense against prosecution or an exemption from prosecution? If you take that approach, the counter argument or concern is that you are making the criminal justice system even more harsh in its impact on people of color than it already is. And so that's kind of an ongoing debate among folks in a number of states who are working to reform the criminal laws. There have been reforms, for instance, in California that have not taken that approach that seem to us to be much more the way to go. North Carolina, interestingly, last year amended its public health regulations to build in being virally suppressed as a defense or as a reason why there's no legal obligation to disclose your HIV status to someone who's a sexual partner, and no basis for prosecution if that were to occur. And the advocates in North Carolina felt that was still an important step forward for further efforts as reform, but it's just important to flag that that's an issue that's an ongoing one. One other policy issue related to this treatment is prevention that I'll mention just very briefly, is that for many, in general, the Americans with Disabilities Act, which is the primary law that protects people with HIV from discrimination, applies to anyone with an HIV diagnosis, but there is a defense in the law for people, adverse employment actions against people who pose a quote unquote direct threat to the health and safety of others. And so the question has been, if I'm a healthcare worker and I'm HIV positive, and I engage in certain types of medical or dental procedures in the course of my job that involve some risk, even if it's very small, of an injury to myself and an injury to the patient, such that there might be blood transmission from me to that person. Do I then pose a direct threat, which would make it legal to restrict me from, say, being a surgeon, from working in an emergency room, from working in a dental office, etc.? And there is now a debate as to whether the individual with HIV who is a healthcare worker, should their viral load, whether it's suppressed or not, be relevant legally to whether it's okay to restrict their practice or ability to engage in certain procedures. It's interesting that all of the evidence on treatment and prevention has to do with sexual transmission and not transmission through, say, an occupational exposure, a needle stick or being cut by, a scalpel or that kind of thing. Nonetheless, that's kind of an ongoing issue. The other exciting biomedical innovation that I want to flag is pre-exposure prophylaxis, or PrEP. And the idea there is that one of the drugs that is part of the standard of care for a lot of people in treating someone with HIV, it's actually a combination of two drugs, but the name of it is Truvada, that if I'm HIV negative and I take a Truvada dose on a daily basis, that virtually certainly protects me from contracting HIV, whether or not I use condoms in a sexual encounter. The statistics are pretty close to like 97–98% protection rate. And the only issue becomes adherence. That, like anything else, if you're not adherent to the medication, it won't be as effective. But because of that, one of the challenges is getting the word out to people and getting people who are at particularly high risk of contracting HIV to at least know about PrEP and to understand kind of what it means to be able to afford it and to be able to adhere to it. And as a general matter, far fewer people at this point are on PrEP than the number that the CDC estimates would actually benefit from it. And to date, most of those people who are on PrEP, frankly, are white men. And so there's a real challenge about getting PrEP and information about it and accessibility to PrEP to people of color, to Black and Latino men who have sex with men, especially young men who are at high risk, to transgender women, especially transgender women of color who are also very heavily impacted by HIV, sadly. So that's a general issue. There's several legal issues besides just the public health challenge involved. One of them is that there have been efforts, and there's a law that was passed in California that actually requires or at least strongly encourages physicians to provide information about PrEP to their patients or to any patient who fits a category of being at high risk because of their sexual practices. And that kind of a law or mandated disclosure by providers to patients is under consideration in other jurisdictions. But there is an interesting legal question raised by a Supreme Court case last June, which is the National Institutes of Family and Life Advocates versus Becerra. It was a case that came out of California. The site is in the materials that are available to you, that basically said a law in California that would require certain anti-abortion centers that in essence were masquerading as women's health care centers to disclose to pregnant women who might consult with them that, you know, abortion was actually an option for them and was available at no cost or low cost to many people in California under various public benefit programs. And the Supreme Court, or a majority, struck that law down and said that was a violation of the First Amendment rights of providers. And so that raises interesting questions about how you encourage or mandate providers to provide information about PrEP to people who really need it. A couple of other legal issues. One is that in some states, a number of advocates have received a lot of reports of people being turned down for certain types of insurance, health insurance, not health insurance, excuse me, life insurance, disability insurance, or long-term care insurance if they're on PrEP. And the rationale apparently is from the point of view of the insurance companies that if I'm on PrEP, I must be engaged in high-risk sex. Which is kind of crazy because the purpose of being on PrEP is to reduce or substantially reduce, if not virtually eliminate, your risk of contracting HIV. So that has been a problem. It's received some publicity, and there was a case brought by GLAAD, which is an advocacy organization based in Boston, against Mutual of Omaha, which just settled on terms where Mutual of Omaha agreed to abandon that practice that they had. There's also been a ruling out of the state of New York that that's illegal under New York insurance law. I believe California has at least started an investigation of the practice, and there's a bill pending in the District of Columbia Council that would outlaw it as well. One other thing I just wanted to flag briefly is that there is a continuing issue about the affordability of PrEP, and the pharmaceutical manufacturer of Truvada, which is Gilead, has for a number of years had a patient assistance program or a patient coupon program that will pay up to, I think now it's more than $7,000 a year of somebody's out-of-pocket costs for PrEP if their insurance won't cover it. But a number of insurance companies are now implementing what is called a copay accumulator clause, which will say if, for instance, my deductible, annual deductible under my insurance plan is $3,000 a year or $2,000 a year, which is not unusual, that if I receive this benefit from the pharmaceutical manufacturer that offsets my costs, that benefit is not credited against the satisfaction of my deductible for the year. And the rationale of the insurance companies is that a lot of drug companies are using these patient coupons to drive patients to their drugs, whether or not it's the best drug, or maybe even if a generic drug is available at a much lower cost. And, you know, I can see the rationale there, but it doesn't apply to PrEP because, number one, there's not a generic available, at least at this point of time, that's realistically available to people. And also, we really want people to be on PrEP as much as possible, or as many people as possible if they're at any kind of risk of contracting HIV. So insurance company policies that discourage PrEP use, whether it's this copay accumulator or onerous requirements for pre-authorization, for instance, or a requirement that you use the insurer's mail order pharmacy, are counterproductive. There are also some interesting issues around making PrEP available to young people, and especially young sexually active men who have sex with men are at very high risk of HIV. They're one of the populations that's most impacted. So there's some legal issues around that as well, which are spelled out in the materials that are available to you. But in the interest of time, I'll stop talking now and turn it over to one of my co-panelists. Thanks.
Thank you, Dan. Margaret,
Okay, can you hear me?
Absolutely. Thank you, Margaret.
Great.
Would you like to introduce yourself?
Certainly.
Thank you.
Yes. So I'm Margaret Drew, and I am a professor at UMass Law School in Massachusetts, Dartmouth, Massachusetts. I come to this work through my representation of survivors of domestic violence. And I was in private practice for 25 years, and since then I've been teaching law students to practice. And some of our work is with survivors of domestic, a lot of our work is with survivors of domestic violence, and some of those are living with HIV or AIDS. So in many ways, since I started practicing, the practice of when representing someone who's living with HIV has changed in some ways, but not in others. Certainly medically, there has been so many improvements for my clients. You know, when I first started volunteering with AIDS Action in Boston, many of my clients didn't survive. That's not the case now, which is wonderful. But unfortunately, what did survive are many of the stereotypes that people have around someone living with HIV, or some of the misconceptions that judges and core personnel and others have. So on the abuse side, much of what we see are you know, a lot of the tactics that are used in abusive relationships generally, where one partner's efforts are designed to control the others. But when we come to HIV, there is the threat of disclosure that is used to control the other partner. There's also concerns about the partner who's being abusive removing medications from the other partner. Or in some cases, we've even seen partners taking the medication so they're using it themselves because they're reluctant to get care. And other times it's simply not granting access to the medication as part of the control over the survivor. What happens in these cases, and I'll address primarily civil protection orders and what happens in family law cases. But also when it comes to confidentiality, lawyers who may file other claims need to be aware of the many ways in which confidentiality can be breached. And this comes from the beginning, having strict office policies on protecting information, confidentiality, trainings, agreements with personnel, because you never know when information might be requested, but the staff in the office has to be quite aware that no medical information is released without the express permission of the client. When addressing civil protection orders first, these become difficult, particularly when the client does not want to release health status, but part of the abuse has been around the health status itself. So as I mentioned, not making medication available, prohibiting the survivor from going to medical appointments. There's a myriad of ways in which healthcare access can be denied through the abusive relationship. And if a survivor wants to obtain a protection order, the choice needs to be made if the abuse is primarily around access to health care and medication, what are the consequences of disclosing that information to the court in order to get the civil protection order. So here, and as in most actions, state law needs to be reviewed, and particularly in what people have access to from the pleadings that are filed. Usually for protection orders, sometimes parts of the pleadings are not public record, or the public does not have access. So that's some protection. But also, once a protection order is filed and if the other side is served, will that person in the interim before a hearing is held disclose your client's medical concerns prior to a public hearing when the hearing is held. One strategy that can be used with that is when the protection order is filed to also seek an order from the court at that point that the defendant is not permitted to prohibiting the defendant or any agents of the defendants, including any attorneys, from disclosing or discussing medical concerns of the client. This also comes up in when the hearing happens. You can request that the court have a closed hearing. If it's going to involve, many judges are reluctant to do that. However, if the arguments are going to concern other issues, you can ask for that portion of the hearing that addresses medical concerns to be a closed hearing. Courts are usually very good about sealing medical records. So most judges will consider closing a hearing around the medical issues, while the rest of it might be public. On the family law side, what happens quite a bit, because so many, more than 50% of abuse survivors more than 50% of those who have been abused and are living with HIV report having been in abusive relationships. What happens is that stereotypes, particularly for women and for young men, when the HIV is disclosed to the court, there are all sorts of stereotypes that surface, including, and this happens particularly with African American women, a presumption that she was engaged in sex work. So there's all sorts of biases and stereotypes that surface with the court, and the attorney needs to be prepared to limit questioning on the origins of the infection. So we just need to be mindful every step of the way that you may not have a sympathetic court. When it comes to custody, the abusive parent will attempt to use the health status of the survivor to limit custody and maybe even to access to the children. as with any disability, if the client has active symptoms or has some limitations due to the HIV, it should be treated just as any other disability would be in a family law case. But overcoming these stereotypes, including, is the mother going to transfer HIV to the children if she cuts a finger or whatever. Some of you have already mentioned some of the stereotypes around transmission. But these are alive and well when a mother, particularly mothers, go to court for custody. Not every client can afford to have an expert witness, but no matter the income level of your client, if you can find a local nurse, someone who's working at a health center to come to court with you and explain how transmission is made and not completed, that would probably be one of the best things you can do for your client and dispel many of these stereotypes. And if someone is symptomatic, perhaps it's someone who has AIDS, again, there's no reason for that person not to have custody, particularly if that has been the parent historically who's taking care of the children. So making the analogy to any other type of disability can be helpful in the courts. And there's limited case law on this. At least one state has case law that says that a parent who has HIV or AIDS, that cannot be the sole factor for not awarding custody to that parent. It troubles me a bit with the sole factor because it's so easy for opposing parties to raise other issues. But again, education of the court is important. Also, when discovery is sent, it's important to get judicial orders that if questions are being asked around healthcare, that there be an order that either the healthcare records are kept at the courthouse, that they cannot be copied, and they cannot be shared. It is an ethics violation for lawyers who may know about a third party's health status to release that to other individuals. And I forget which state, but there was an ethics case recently where a lawyer learned of someone's health status during the course of discovery in one case, and then happened to be speaking with a lawyer for the other side in a different case and revealed the information and was sanctioned. So, but revealing the information, sanctions probably don't really help your clients at that point, because if employers discover the information or others, it could seriously impact your client's life. Excuse me. So one also has to be careful when dealing with the families of the survivors, because very often families are not supportive of abuse survivors. And for them, this information may not have been disclosed. And for them to have this information could do a lot of damage to the survivor, both in workplace, with housing, with all of the other issues that those living with HIV and AIDS encounter in terms of discrimination. So the points I would ask people to really consider is, if you're going to court, to have discussions with your client about whether or not the action is necessary, that particular action. And if it is vital to your client's well-being, then you need to discuss the parameters of what can be disclosed. Sometimes in cases where both parties are living with HIV, there's just an unspoken agreement not to raise health issues. Sometimes it's a spoken agreement not to raise health issues. But you can't always rely on that when the other party is someone who is abusive, because very often what may be agreed to is not, there's no compliance. But courts can be very helpful in this regard in terms of entering orders around confidentiality and disclosure. So again, I am available for questions once we're finished. Thank you.
Thank you, Margaret. I don't know if anybody can hear me. I think then, Evelyn, we're moving on to you. Would you mind to also introduce yourself? Thank you.
Thank you very much. So my name is Evelyn Tomaszewski, and a longtime member of the committee, and this is a fascinating webinar. I'm so pleased to be part of it. I am director of Pearl Associates, which is a consulting firm here in Washington, D.C. I'm also adjunct faculty at George Mason University, Department of Social Work, and recently had a tenure as a director of the NASW National HIV Mental Health Training and Education Project. And what I'd like to do is show some slides to help move us along. And I'm just going to ask somebody if they could confirm that you can see the slides.
Yep.
Great, thank you very much. Appreciate that. So what I'd like to bring together is the syndemics, or the issues around HIV and mental health, stigma and discrimination, practice and policy. And so I have a few slides to review, and then I think it will certainly hopefully fit well with what's been presented. So as you look in front of you at the next slide, we see that, oh, sorry, did I just do something wrong? Are the slides still there? Yeah? Aha, got it, okay. Sorry. So a meta-analysis of 29 studies showed that depression treatment improves adherence to antiretrovirals. And Dan spoke clearly about the range of health benefits already of ensuring that you're on antiretrovirals. But what we do know is that a mental health diagnosis can emerge as a result of stressors around HIV, around other myriad of other life events. Anxiety is found or diagnosed or experienced about 47% of people living with HIV. And that's not necessarily an anxiety disorder, but feelings of being anxious and anxiety. Persons living with HIV are 2 to 3 times more likely to experience depression compared to those who are not living with or diagnosed with HIV or AIDS. This depression often, and as well as anxiety or anxiety disorders, often go undiagnosed. They impact the severity of overall health symptoms and create poor health. They are known to increase substance misuse and other high-risk behaviors, and have an adverse impact on treatment adherence. As I mentioned, non-adherence to treatments, both antiretroviral and medications for depression. I've already mentioned about the meta-analysis of 29 studies, but what I wanted to also add to that is the data found that non-adherence was 35% greater among people who did not receive care for their depression. And those who did receive treatment or therapeutic interventions, and that could be support groups or clinical therapy interventions, stress reduction for depression, their successful adherence was 83% higher. I think that's a very, very powerful numbers. So I wanted to talk a little bit about what we know, and this is information from the HRSA website. And it talks about their health center programs, that approximately 90% of health centers provide mental health counseling and treatment, so it's really very good. Yet 69% of health centers provide substance abuse services. And what HRSA is increasingly committed to ensuring patients or clients have access to behavioral health services as part of their primary care, we can see that the data, particularly when we look at the Ryan White programs, that there are some gaps that exist. For example, while it's estimated that 10 to 28% of people living with HIV have co-occurring substance abuse disorders and mental illness, and what that means is they are both diagnosed with having active substance misuse or substance abuse, and a mental health problem, depression, clinical depression, chronic anxiety, etc. But as of 2015, about 13% of clients receive mental health services from providers. And what that means is that there is a gap in my reading of folks who need access to care. And what we've already seen in the data is the critical importance of the connection of HIV medication adherence and the diagnosis of treatment and overall health and wellness. The next slide I want to look at is something that we created when I was at the National Association of Social Workers at the HIV Mental Health Training Project. And we looked at the National HIV/AIDS Strategy. You'll see very clearly the care continuum, very familiar to folks. And beginning at looking at prevention of HIV all the way through to sustaining health and wellness. And this, as you read this, highlights a range of skills and opportunities that we have to work across the continuum to both provide support and resources and to reduce risk as we work to end HIV and AIDS. And as you review the information, I think you can also look at it from the lens of your own discipline, your own work environment, your own skills of how you might fit across the continuum. But if, for example, in HIV prevention, persons with mental health or psychosocial issues really need to have full access to HIV prevention messages. Supporting legislation and anti-discrimination, anti-criminalization strategies certainly are connected to prevention efforts. And then Dan spoke about the ensuring or access to PrEP, but also the reality of the impact of race, racism, and gender discrimination in folks even having information or access to PrEP. We look on to diagnosis and linkage to treatment, the outreach and inclusion of voluntary HIV testing in community mental health centers or behavioral health programs beyond those that are HRSA funded or publicly funded, really integrating an outreach of HIV into mental health centers. Offering psychosocial interventions as part of an integrated package of services that includes antiretrovirals, sexual reproductive health services in collaboration with community organizations. We look at ARV therapies and viral suppression, again, ensuring access to screening and treatment for depression and the requisite care planning as a standard of care. And then providing access to social supports. And then on to sustaining health and wellness. Many of the speakers already addressed the idea of structural barriers, but really ongoing addressing of violence prevention, housing, stigma, poverty, the lack of providers and awareness. If we don't create and sustain an educated provider community, then how do we help sustain health and wellness for those that we're serving and working with and ourselves? And then, of course, cross-disciplinary collaboration and shared learning, which is one of the reasons I'm so pleased to be part of this webinar with majority folks in the legal field to really look at how we can collaborate and do shared learning. The next thing I want to connect with is the idea of stigma and discrimination. It's been brought up again by a number of my colleagues on the webinar, but it's universally experienced by people living with and affected by HIV, as well as people with mental illness or general mental health problems. You know, at the individual level, stigma takes the form of behaviors or thoughts or feelings that express prejudice against a person living with HIV or AIDS or those that are in their social circle. It can also be experienced by others perceived to being living with HIV or AIDS or mental health problems. I noted that Margaret gave an example that I think is an example of the impact of stigma that results in a real concern about HIV disclosure and safety for some of the women that she serves and works with, and that bias, that stigma, can be shown in custody decisions, and that's a very clear example. Stigma, discrimination, criminalization laws, and social prejudice negatively impact the social and psychological health and well-being of persons living with HIV and certainly affect communities. But we know the evidence shows that they're associated with low social support, poor physical and mental health, and poor quality of life, all things that are of great concern. So, again, stigma's been linked to anxiety, depression, self-esteem. And I want to talk briefly about societal level stigma as it's manifested in laws and policies, popular discourse, social conditions in which we live. It can delay or impede our getting help and treatment. And Anthony presented in the very beginning of the webinar a really great example or powerful example of the impact of systemic discrimination on the careers of a number of military personnel. Addressing stigma, and I just do want to make note, going back to my own notes here, that I know in the State of the Union, stigma was identified as a debilitating barrier to receiving health care and the services and respect that all deserve. And I bring that up as I go to the next slide, as we look at two documents or two guidance documents that are really helpful for me as I think about stigma, discrimination, mental and behavioral health, and HIV. The National HIV/AIDS Strategy highlights broad-based efforts to reduce stigma of common co-occurring conditions, which I've identified as mental health, substance use, etc. It states that federal agencies, health departments, and community-based efforts should dismantle stigma discrimination in clinical settings. I want to highlight something recently that was published is the Global Partnership for Action to Eliminate All Forms of HIV-related Stigma and Discrimination. Last fall, 5 focus groups were convened around the world, and the North America focus group was convened here in Washington, D.C., where stakeholders talked about addressing stigma and discrimination. In December, the Global Partnership via UNAIDS released a report on the call to action, and in the notes section of these slides, you'll find the links to both of these documents. But this slide, to me, highlights a few recommendations that are relevant and doable as part of our U.S. commitment to address stigma and discrimination and to end AIDS. Partnering with stakeholders to address HIV-related discrimination, implement evidence-informed policies and programs that are measurable and can be duplicated, can be scaled up, and to allocate the resources to finance implementation, monitoring, reporting of activities. And I think that's a really critical issue of we can say we want to do it, we can place it into the general, the global conversation, the domestic conversation, but we need to work and ensure that there are resources to make that happen. So finally, I kind of put together some policy and practice recommendations, and these again are connected to the broader issues of HIV and mental health and stigma. Include persons with mental health diagnoses and or substance use disorders on all levels of decision-making, program planning, and case management. And Ronda spoke clearly about the importance of the lived experience as part of our work. Expand and target funding for comprehensive and accessible mental health and substance abuse services as part of case management services. We want to work to support research and implementation studies for initiatives that address the systemic HIV, mental health, substance use, interpersonal violence, poverty, and discrimination. I think it's an opportunity ahead of us to scale up and grow current training of mental health and behavioral health providers on the principles of HIV care and treatment, as well as increased training of primary care providers on assessing basic assessment tools around mental health, substance use, and basic psychosocial interventions. And then expand the national HIV/AIDS goal of support, screening, and referral for full integration of screening for and accessible access to substance use and mental health services. So screening and referral beyond HIV, or inclusive of HIV, but also around substance use and mental health services. So thank you very much for your time, and I look forward to our conversation.
Thank you, Evelyn. Bill?
Hi, everybody. This is Bill McColl. I am the Vice President for Policy and Advocacy at AIDS United, and I'm very pleased to be here. I've been a member of the coordinating committee for a number of years, and it's great to be able to put on this webinar. Actually, you've probably seen me get up out of my chair and wander off a couple of times during the webinar, and that's because I've been in the process of responding to the State of the Union address that happened last night. I think, as Evelyn mentioned, that there is the president talked about creating a new plan for ending the HIV epidemic in the United States. And I think I've got a few details that I can provide for you about the plan that I think people will be interested in. But then I have a very specific issue around the Medicare Part D, 6 protected classes that has the potential to create very severe issues for the epidemic right now. And so I think, in the one hand, we're going to very cautiously say that we welcome the new HIV epidemic plan, while secondarily cautioning that there have been quite a number of issues that have popped up around the way that the Trump administration has been administering healthcare, as well as other issues. What I do want to say is that the plan, I think, is the result of a lot of hard work by the HIV/AIDS community that, beginning even before the election in 2016, a number of groups within the community were talking about what is it that is our next step for the epidemic. And a good part of that next step is actually the fact that we needed to update the National HIV/AIDS strategy to move the goals of that strategy from a 25% drop in number of new cases to something that basically much closer approximates the epidemic, or ending the epidemic, I should say. And one of the reasons that we think we can do that is, as has been mentioned earlier, I think by Dan and others, that we now have clear evidence and technology from the basically from the studies that have come out that show that if we can get as many people as possible into a situation where they are undetectable with their viral load, then they also will not transmit forward. And if you could do that at scale in the United States, it is possible to begin to roll back and bend the curve on the epidemic and eventually to end the epidemic. So we have that technology, and particularly when you combine it with pre-exposure prophylaxis, the use of medications for prevention, which also have a very significant rate of success, then we do think that that this is doable. So the administration's plan itself is very interesting. It has basically announced the goal of a 75% reduction in new HIV infections in 5 years, and then a 90% reduction in 10 years. This matches some of the global goals with the 90% reduction in 10 years. It's certainly, should we actually begin to meet those goals, it would signal the end of the HIV epidemic, which frankly is something that I don't know that I would have ever expected to see in my lifetime, but it is now something that's within reach and has been announced as a goal by the United States government. It's in some ways very exciting. Hold on to that thought, because there's some other pieces that I want to talk about. Their plan, though, is to do basically 5 things. Create is basically to diagnose all people with HIV as early as possible after infection, to treat the infection rapidly and effectively to achieve sustained viral suppression, to protect people at risk for HIV using potent and proven prevention interventions, including PrEP, so pre-exposure prophylaxis, a medication that can prevent HIV infections, to respond rapidly to detect and respond to growing HIV clusters and to prevent new HIV infections. And then an HIV health force will establish elimination teams committed to the success of the initiative in each jurisdiction. So those are the 5 things that they're saying that they would like to do. There are a couple of things that also bear mentioning. The main thing is that the initiative is going to target resources to the 48 highest burden counties, Washington, D.C., San Juan, Puerto Rico, and then 7 states with a substantial rural HIV burden. So we understand that there will be new funding coming in to work on the epidemic, but it's also worth stating specifically that they are going to focus on areas where HIV transmission occurs more frequently. They note that 50% of new HIV diagnoses occur in these 48 counties, DC, San Juan, Puerto Rico, and then that 7 of the states with a substantial rural burden have over 35 cases and 10% more or more of their diagnoses in these areas. So by concentrating on those areas, I think that they can more selectively focus on the epidemic. I will just note that this is all great if it comes to fruition. However, as we have seen, there have been very serious issues with the Trump administration in terms of administration of healthcare, including attempting to first repeal the Affordable Care Act and now to limit ways that the Affordable Care Act operates. AIDS United is actually involved in a lawsuit right now as plaintiffs against the administration for creating new regulations that would allow short-term limited insurance to become available for 364 days and renewable for 3 times. Clearly not, which actually would undermine the Affordable Care Act marketplaces, because individuals could seek essentially insurance that doesn't match the marketplace standards, renew it for very close to 3 years, and then essentially not be forced to pay insurance, the marketplace insurance rates. That's considerably problematic because it has the potential to move younger, healthier populations that the marketplaces need to survive into that type of insurance, creating the potential for a what's known as a death spiral for the Affordable Care Act marketplaces. They're also doing things like creating regulations that would allow or that would require work requirements for Medicaid, and finding other ways to limit the Affordable Care Act, as well as undermining Medicaid expansion. They've also proposed budget cuts to parts of the Ryan White Care Act, including the AIDS Education and Training Centers, the Special Projects of National Significance, as well as other HIV funding outside of the CARE Act, including Minority AIDS Initiative funding in the Secretary's office and at the Substance Abuse and Mental Health Services Administration, as well as cuts to prevention. All of these things, I think, sort of militate against the success of their HIV plan. And then finally, we already know that there are just a number of ongoing issues with the way the administration has worked to essentially place new barriers in around immigration and being able to access treatment and care for both legal immigrants as well as people who are undocumented. And then finally, for creating new barriers and discriminations around for LGBTQ people, and then certainly a perception that people of color are also less likely to be able to receive services that are necessary for ending the HIV epidemic. So I'm going to go ahead and stop there, but I'm just going to say that, so on the one hand, the our excitement around the creation of the State of the Union ending the HIV epidemic plan for America to move forward is tempered by what we've seen in terms of the previous 2 years. And I haven't even mentioned that there is not a plan to fill the directorship of the Office of National AIDS Policy, although after a year of being defunct, they are now in the process of recreating the President's Advisory Council on HIV/AIDS. I did want to mention one other issue specifically that we've been working on, and that has to do with Medicare Part D's prescription drug. Basically, the part of Medicare that allows older Americans access to affordable drugs, as well as Americans who are disabled. At the time it was established, which was in 2003, it created 6 protected classes of drugs to ensure that people living with serious chronic or infectious health conditions would be able to access the drug, the specific treatments that their medical providers prescribed without interference from insurance companies. And we know that right now more than 250,000 people living with HIV actually rely on Medicare to keep them healthy and to suppress the virus. Just recently, the Trump administration on November 26th of 2018 announced the Modernizing Part D and Medicare Advantage to lower drug prices and reduce out-of-pocket expenses proposed rule change. Basically, that rule change would loosen protections extended to the 6 protected classes of drugs. Just so you know, the drug classes are antidepressants, antipsychotics, anticonvulsants, immunosuppressants, which are the drugs used to prevent transplant rejection, antiretrovirals, and then anti-neoplastics, which I will confess I don't know what those are. At the same time, so these changes create a situation where it could allow insurers with Medicaid to require prior authorization, as well as also militating against, so it might actually create situations where people are not getting the drugs that they need to get virally suppressed, which I just discussed as a precondition for preventing new transmissions forward. And then also the proposed rule removes restrictions against step therapy, which is something that also we're concerned about. It basically means that insurers would be free to require enrollees living with HIV to prove that less effective medications don't work before agreeing to cover more effective but expensive treatments. The problem is that it could delay or interrupt individuals' journey to viral suppression, but also it means that drugs with fewer side effects might be tried last. And then moreover, if somebody fails a particular course drug regimen, it also means that they might become resistant to not just that drug, but to an entire class of drugs, which obviously is really a concern. So AIDS United is opposing this particular change by the administration. So on the one hand, we're kind of cautiously supporting this new plan while working in opposition to kind of a number of different administration things, including this one. A lot of that work, if you want to send in letters to Congress, for example, to let them know that you oppose this, are up on our AIDS United website at aidsunited.org, and we certainly encourage people to get active. So those are some of the sort of advocacy work and sort of policy things that are going on around HIV. I will just tell you that it's a really exciting and interesting time to be working on HIV right now. I do think that there's a lot of potential for this kind of first ever announcement of trying to end the epidemic to really bear fruit. But to do so, the administration is also going to have to rethink some of their approaches to things like immigration and their public charge rule, to rolling back the Affordable Care Act and opposing Medicaid expansion, and just finding ways to get people into treatment and care. So it's kind of a mixed blessing. I think at this point, I'm going to turn the conversation back over to the moderators. I think those are the major points that we'd like to cover, but I do appreciate the opportunity to speak with you, and I'm hopeful that this has been helpful to you.
Thank you, Bill. Rhonda?
Yeah, so I'm sorry for the noise. Philadelphia is a little loud. We've been talking about all of the hard work that this group of folks is working on, and we thought it would be a good idea to end the presentation, not the question, but the presentation, with a little bit of a positive update. So some of you may recall that more than a year ago, the AIDS Law Project, along with the Legal Action Center and the law firm of Conte, brought a federal class action suit against Aetna for a really awful breach of privacy. You might remember this case. This is they sent out 12,000 envelopes, and that the letter inside was situated in a way that you could read like, "Dear Joe Smith, we are writing to you about your HIV medications." And it caused tremendous privacy concerns, as you can imagine. And we heard just terrible, painful stories of people who kind of kicked out of their families, kicked out of their homes, lost jobs, all the things we know that happens when that kind of stuff gets out. We were able to negotiate a really favorable settlement with Aetna. So we reached a $17 million settlement. You know, us small public interest law firms, that's a whole lot of money. We were particularly pleased that it resulted in individual benefits for each person of a minimum of $643. Plus, if you had some additional financial and non-financial needs, you could make a claim up to $20,000. And so that's a lot for a class action resolution. It also included a promise from Aetna to provide some best practices and change how they do things. And so I think that what happened is, not only is Aetna going to be better, everybody else, we hope, who's watching following that case is also going to be better. That was a big $17 million signal to the idea that if you're holding information that's sensitive and confidential, process that carefully. You need to rethink your privacy programs. So while we have great sorrow for those who were affected by a breach of privacy, we do hope that there will be a positive message going forward for others. So thank you. I'm going to drown out Philadelphia and go back on mute. Over to Dan.
Congratulations.
And Richard, I just want you to know this is Allison. I'm on the line.
Oh, great.
Yay.
I'm getting off now, Allison. Thank you. Go ahead.
Okay, I'm going to do a brief presentation, and I'll make it very brief since we're nearing the end. First of all, thanks to the ABA AIDS Coordinating Committee, to Paula, to Richard, and I'm very sorry. I heard all the presentations, and I'm very sorry that you will not see me on the screen, but you know, just think of a picture of Angelina Jolie, and it's about right. I'm going to talk a little bit about HIV criminalization laws, and I want to credit 3 organizations: Lambda Legal, the Zero Project, and the Center for HIV Law and Policy, all of which are doing fine work in this area. HIV-specific criminal laws exist in 30-ish or so. The number changes here and there. And what that means is it's specifically geared toward HIV. That doesn't mean if you don't have a specific HIV law where you live that you cannot be adversely impacted by a criminal law if you're a person who has HIV, because they can easily use an existing assault or other type of law that's not specifically designed for those with HIV to accomplish essentially the same task as an HIV-specific law. And while the laws vary a lot from state to state, they do generally share many common elements. In almost none of these laws is the specific or even general intent to transmit the virus required. Transmission of the virus is not required. The laws often cover behaviors where no risk of transmission exists, and that can include things like biting and spitting, but it can also include things like oral sex and other type of sex for which there really is no risk of transmission, even in the absence of risk reduction measures. So in many of these laws, the requirement really is that you have to disclose your status prior to undertaking sort of any kind of behavior that's sexually related, whether there's a risk of transmission or not. So it's really a failure to disclose more than it is an intent to transmit type of situation. That's true in almost all states. In addition, no meaningful defenses are allowed, which means that if you don't disclose, it sort of works like a strict liability law. You are guilty. It doesn't really matter in some of these places what the behavior was, what the intent of the parties was, and whether or not somebody was adhering to risk reduction measures, whether it was the type of behavior engaged in carrying no or low risk, or use of condoms or other prophylactic measures, or whether it's being on the medications on either side of that transaction. Generally, those just don't appear in these laws. So it's really, as I said, you don't disclose you have sex, someone reports, you are guilty. There's very little left to do for you. In addition, they are often very high felony level, carry lots of time in jail. And in addition to that, they also, with respect to sex worker laws, which we have in every state, I think, except, and even Nevada has one that's a misdemeanor. So if you're a sex worker and you're arrested and you don't have HIV, you get a misdemeanor level penalty. If you do have HIV, you often get a felony level penalty. And in addition, often convictions under any of these laws will result in the person being placed on the sex offender registry. And I think people are generally aware of the pretty dire consequences of that in terms of kinds of jobs you can hold, where you can live, having to put that on every job application for the rest of your life. And so that is another sort of dire consequence. So these laws are serious business, and there are many really smart, well-intentioned people that have been working on reform efforts in various states. You know, all politics is local, and all reform efforts really have to be local because it takes a local knowledge of state legislatures and local politics in order to make effective change in these cases. And so while advocates in different states have taken different political approaches, the general trend is toward modernizing the laws as opposed to repealing them altogether. And that's in part because, as I said, even if you repeal the existing HIV-specific law, there are going to be remaining criminal laws that can and have been used to prosecute people for effectively the same behavior. And so some of the things that people want to probably keep in mind as they go through this modernization process, you certainly want to eliminate any sentence enhancement that results from being an HIV-positive sex worker. You want to make sure that all the burdens of proof are assigned to the prosecutor. So in other words, the prosecutor has to come forward with proof beyond a reasonable doubt for all of the elements. It shouldn't be left for the person to defend themselves, because the prosecutor's person is going to have all the information, and the defense may not be aware of that. I think it makes a lot of sense to make the law applicable to all non-airborne, contagious, or infectious diseases, and not just HIV in particular. And I know there's a lot of discussion and well-intentioned conversation and rigorous debate going on about this. There are two sides to that story, whether you dilute the stigma against HIV by adding other non-airborne contagious or infectious diseases, or whether you don't do that. But it certainly should be a consideration in your deliberations that you're having over how to proceed. I think it's critical in all circumstances to include some requirement that the law only be applicable to those acts where there is a specific intent to transmit. So specific intent in criminal law is sort of the highest standard you would have to meet. But I mean, I would take a general intent if I could get it. But some kind of specific intent, general intent to transmit, and ensure also that there's language that folks who are engaging in that conduct, even if they are intending to transmit the virus, still have to be engaging in behavior that carries a substantial risk of transmission. So if someone is engaging in, is biting someone and hoping to transmit the virus to them, the fact is that doesn't happen. It doesn't get transmitted that way. And so that person should be eligible for prosecution, despite the fact that they're stating an intent to transmit. So an intent to transmit, and also coupled with conduct where there's a substantial risk of transmission. And there are a variety of definitions of substantial risk. I, of course, always want the highest, most difficult to prove on the prosecution side. Some have put forth this definition: a reasonable probability of transmission as proven by competent medical evidence. I do think, however you otherwise define substantial, or how it might already be defined in your state law, it's critical, this language around you have to use competent medical evidence, and it can't be based on myths, fears, and stereotypes, or some kind of local knowledge of the probability of risk of transmission. I think that it's incredibly critical to have that standard that is common among all. And then I think some have incorporated a statement that the prosecution cannot meet its burden of proving specific intent where the person living with HIV undertook or attempted to undertake practical means to prevent transmission. Practical means to prevent transmission. That would cover any kind of method, device, behavior, or activity that is demonstrated, again, by competent medical evidence to be epidemiologically proven to measurably reduce or limit or eliminate altogether the risk of transmission. And that, of course, would include things you're very well aware of: use of barrier protections, use of ART, and anything that may come to us in the future that we don't yet know about. So that's a broad summary. And again, I would refer you to Lambda Legal, the Zero Project, and the Center for HIV Law and Policy, each of whose websites has far more detailed information about the HIV-specific criminal law in your particular jurisdiction.
Thank you, Allison. We only have a few minutes left, and I wanted to start with one question for the panelists that we've received, which is, what are the panelists' ideas and suggestions for law students and young lawyers who want to be involved and active on these issues? So who would like to address that?
I can talk to a little bit of it, since I am a fairly new attorney. I've been in practice for about 1.5 years. So my personal experience was I started interning for credit at a very, very small HIV services nonprofit here in Los Angeles, which just so happened to be working on California's HIV decriminalization statute, which is how I got connected with the folks at Lambda Legal. So I think it's important to obviously hold yourself out as an organization that can bring law students on to intern for credit. But I think what was more important was that I had people who advocated for me, both the attorney at the nonprofit and my current boss, the head of our HIV project, Scott Chavez, both really made a point to advocate for me and get me involved. And I certainly would not be at this organization now doing the work that I'm doing if not for the two of them. So I think it's, I'm sure it gets said all of the time, but mentorship and internships and providing opportunities for people to get their foot in the door is really, really important. And if you see someone whose work you like, help them stick around whatever way you can. It may not be that your organization has the ability to pay them outright, but perhaps help them, point them towards external fellowship funding, that sort of thing. And even if they can't come immediately, in a couple, keep your eye on them. So in a couple of years, maybe they can come back. Things like that are super important, particularly for people like me who are at the beginning of their careers.
And I would just jump in from the other side and say, for young lawyers or law students who themselves want to get involved, that it's really important to volunteer. Any place you can, find the organization or organizations in your area who are doing this work, and the AIDS Coordinating Committee of the ABA keeps a list of that, which is online on their website. But volunteer any way you can, because that's the way that those of us who are in the nonprofit world, who have kind of limited resources, find out about people and get to know them, and you get some experience. People get to know you. You learn more about what the opportunities are. So I would say, whether you're interested in actually litigation experience, policy work, anything you can do to help out, the organizations that are in your area, absolutely take advantage of that.
I would add that most schools now have a pro bono requirement, and find that organization that's in your local area, but you don't necessarily have to wait for legal work to come along. Whatever that agency needs you to do, I would volunteer, whether it's showing up at hearings or community education, whatever it is, I'd volunteer. And then you will meet folks who are on the legal side, and you'll be familiar to them and would have already been familiar with an organization.
Well, that's all the time that we have today, but we, on behalf of the Section of Civil Rights and Social Justice and the AIDS Coordinating Committee, want to thank everyone for attending, and also to our panelists. This was an incredibly insightful and interesting discussion, and we're very, very grateful for the time that you took to participate. So thank you so much.
Thank
I
you.
will be sending, great, and I will be sending out a recording and the materials to all of our registrants. But thank you so much again.
Thank you.
Thank you, everyone.